Ready? Start. In the present appeal, the insurance company has challenged the award only on the ground that the compensation awarded to the claimant is excessive and arbitrary, and rate of interest awarded by the tribunal, that is 8% per annum, calculated from the date of filing the claimed petition, is also arbitrary. Full stop. It was argued by the counsel for the appellant that in column 6 of the claim petition, the claimant has stated the income of the deceased to be rupees 15,000 of the per annum, and therefore the tribunal had acted arbitrarily in determining the compensation on the basis of a national income of rupees 20,000 per annum. Full stop. It was also argued by the counsellor for the appellant that the deceased was a bachelor, and therefore, while determining the multiplication, 15% should have been deducted as personal expenses from the notional income of the deceased, and the tribunal has erred in the deducting only one third as personal expenses of the deceased. Full stop. It was argued that, in view of the aforesaid, the award of the tribunal is liable to be modified by the compensation payable to the claimant. Full stop. Para. Rebutting the argument of the counsellor for the appellant, the counsel for the claimant has argued that the income of the deceased was stated to be rupees 15,000 per annum, column 6 of the claim petition, on the basis of the notional income provided in paragraph 6 of the second schedule. Full stop. It was argued by the counsel for the claimant that under section 168 of the Act, 1988, the tribunal is required to hold an inquiry into the claim and award just compensation, and the compensation payable to the claimant would not be reduced because a lesser amount was claimed as compensation in the claim petition. Full stop. In support of his cross observation, the counsel for the claimant has argued that from the evidence on record, it was proved that at the time of his death, the deceased was earning rupees 5,000 per month, and therefore, the tribunal enacted arbitrarily in the compensation on the basis of a notional income of rupees 20,000 per annum. Full stop. It was also argued by the counsel for the claimant that the multiplier has to be decided the age of the deceased and not to the age of the parent of the deceased. Full stop. It was further argued that the tribunal had also erred in not awarding any amount to the claimant for the funeral expenses and loss of the estate, as well as for loss of love and affection. Full stop. It was further argued by the counsel for the claimant that the claimant was entitled to interest of 12% per annum, and the award of the tribunal awarding merely 8 per percentage of the interest of liable to be modified. Full stop. Thus, it is held that the decrease was unemployment, and the argument of the counsel of the claimant that the compensation should be determined taking the interest of the decrease of rupees 5,000 per month is the rejected. Full stop. The notional income of the deceased and the consequently compensation payable to the claimant is decided later on the judgment. Full stop.